Your Honour, my name is Benson, B-E-N-S-O-N, initial L, and I appear for my client, Mr. Johnny Wishbone, today. This is an application by my client for a ruling pursuant to Section 590AA of the Criminal Code that the admissions documented by police said to have occurred on the 23rd of June 2016 be excluded in its entirety. My client is currently charged with 106 counts of break and enter. The application is made on two bases. The first, that the record of interview by police should be excluded because the applicant's admissions were not obtained or recorded as per the statutory provisions of the Police Powers and Responsibilities Act, henceforth known as the PPRA. The second basis is that even if the admissions are found to be in accordance with the statutory provisions and therefore admissible in law, they should be excluded on the basis of unfairness and/or public policy grounds, which involves an exercise of judicial discretion. There has been no formal plea of guilty submitted, and thus I am instructed by my client that he plans to exercise his right to trial by jury, before which the issue of inadmissible evidence must be addressed. The case against the applicant is based almost entirely upon supposed admissions which were made during police interview. The essence of Mr. Wishbone's application is that through the failure of police officers involved in my client's arrest, questioning and subsequent charges, failed to comply with several sections of the PPRA, the Police Powers and Responsibilities Regulation, and the Regulation Code, mandating that the evidence obtained relating to such failures is to be excluded by the court. The police failed to record the conversations after the apprehension of Mr. Wishbone and before the record of interview commenced. There was no field recording of the transport to the police station. Section 435 and 436(2) of the PPRA state that all cautions and questioning of relevant persons should, if practicable, be electronically recorded. As per Section 436(3), admissions during questioning are then only admissible if recorded, with the exceptions outlined in Sections 437. The police officers did indeed provide a written record as provided for in Section 437. However, this written record was provided at the back of a police statement 3 months after the day of the arrest, which is clearly beyond a time frame reasonably practicable after questioning. No other exceptions in the Act apply here, and in the interest of justice, as in the Crown and Dwelling, does not permit the admission to be admitted despite these breaches. Additionally, pursuant to Section 421 of the PPRA and Section 25 of the Police Powers and Responsibilities Regulation, it is reasonably suspected that the person is a child, which here clearly he is, and the officers must not question the child unless a person of their own choosing is present. On the facts, there is a person supposedly in a position of support for Mr. Wishbone, but this is not an independent person. The police were required to contact the applicant's parents or guardian, which here they did not even attempt, despite Mr. Wishbone being in custody for quite a long time. Furthermore, Section 26 of the Regulation Code, which regards cautioning the relevant person about their right to silence, subsection 1 of which sets out what the officer must state, and 2 and 3 which specify that if the person believes that the accused does not understand the caution, they are obligated to ask the person if they understand the caution and to further explain if required. Here there is obviously been no attempt at that. Given the above failures in regards to the relevant statutory provisions, I implore Your Honour to exercise island discretion, which entitles you to exclude evidence which is more prejudicial than probative when obtained inappropriately or illegally, as it has been here. Even if Your Honour was not satisfied that these aforementioned procedural breaches prevented the admissions from being allowed into evidence, the issue of voluntariness arises, to which the court is entitled and here implored to exercise the use of the unfairness discretion or the use of public policy discretion, both of which I argue are applicable here. In the Crown and Lee, it is provided that the confession must have been made in the exercise of free choice to speak or to be silent, and not because the will of the accused was overborne due to sustained or undue insistence or pressure. As in the facts, the applicant was not once advised of his right to remain silent, thus infringing on the common law admissibility. The applicant was told, and I quote, "Just tell the truth and answer the questions." This direction is in direct opposition to the established right to silence, as well as in contravention to the fundamental duties of a supposed support person. Additionally, it was highlighted in the Collins and the Queen that the admissibility of confessions is determined by the effect of the officer's conduct in all of the circumstances upon the will of the accused, and it is necessary to consider those circumstances in respect to the age, background, and psychological condition of the accused. Given that the applicant here is an Indigenous juvenile, it is arguable that the conduct of the officers and failure to provide a support person and advising him of his rights to remain silent, the assessment of whether or not the admissions were voluntary would likely find that the admissions were not in essence voluntary, after considering the actual circumstances of the case and the applicant. The applicant was clearly operating under a misapprehension which was compounded by his naivety. Section 130 of the Evidence Act, or the Christie discretion, provides that nothing in this Act derogates from the power of the court in a criminal proceeding to exclude the evidence if the court is satisfied that it would be unfair to the person charged to admit the evidence. Particularly here, the unlawfulness of the police conduct is relevant in determining the fairness of the admissibility of evidence. Since it is a policy of law that a criminal trial be fair, considerations of actual or possible unfairness to an accused should be heavily weighted. In regards to public policy discretion, it is evident here that there has been a blatant and reckless disregard for the law and due process in relation to the questioning of Indigenous youth. There is no evidence that exceptional circumstances were relevant to excuse the shortcomings of the officers. To conclude, Your Honour, as demonstrated, there have been numerous violations of statutory provisions and regulations in regards to obtaining the applicant's admission, which should in itself be sufficient to exclude the evidence from court. But furthermore, the exercise of fairness, discretion and public policy consideration should solidify the reasoning to exclude Mr. Wishbone's apparent admissions from the prosecution's evidence. In conclusion, Your Honour, I seek that the admissions of the applicant obtained on the 23rd of June 2016 be excluded from the Crown's evidence. Thank you.